Now, again, we need the collection of records, the Transparency Act, and we need that joint rule. And again, if you're in the Article 5 movement, trying to get an amendment passed, trying to get a convention call, maybe you just have been trying to get Congress to pass an amendment to the Constitution, or trying to fix voting rights, or whatever your pet issue is, this can be the solution for you. It could be the path to victory for whatever your issue is, basically, potentially, if it's popular enough. But whatever your cause is, please, this is kind of a nerdy thing. Not a lot of people are going to be talking about this in the media, but if you believe that this is a solution to a lot of the problems that we have in the country, help us put pressure on Congress to pass the Transparency Act and to create this joint rule. And if it doesn't work, we'll be helping you in your states on these other issues. But, there's really no ambiguity left. We know without any question, if this happens, we will have a convention. It's like what you had said before too, Bill. It's like stacking logs against a door. Once you open that door, they're all going to come rolling in. This is a bottled up process for hundreds of years, really. And you're going to see it come to full fruition here pretty soon. So help us. If it doesn't work, we'll be out there to help you. But I promise you, this is exactly what we need to happen. I am joined today with Bill Walker from the Friends of Article 5 Convention group. He's the director over there, and a friend and associate of mine for many years with articlev.org. I'm Dan Marks, and we're here today basically because we want to make it clear what the rules are with the Article 5 process, the Article 5 amendment process, and how we begin the call for a convention to propose amendments to the Constitution under Article 5 of the convention. And we wanted to kind of relay some of the things we've discovered, truly discovered over the last couple years, really. But things have really snowballed all at once here. And real quick, Bill, say hi to everybody.
Hi there.
Bill and I were fortunate enough to have the opportunity to meet with the Parliamentarian of the House, Tom Wickham, and Member of Congress, Jared Polis, last summer. And we were discussing the Article 5 process. And that's what we're here to do today, is to kind of relay the gist of that conversation. I want to give you a little bit of backstory on this. First of all, Bill, as I said, is from the Friends of Article 5 Convention group, and notably from the Congressional Research Service report, a big contribution to the effort, mainly with the collection of records that you'll find on their website. And Bill, can you tell us about how those records came into existence, and how you ended up putting them on your website?
Yeah, FOABC got formed in February 2007. We were the first national group to advocate the calling of an Article 5 convention. We are nonpartisan, that is, we don't favor any particular amendment, and we still maintain that. We may refer to amendments and so on and so forth, proposed amendments, in our research and information, but we do not advocate any specific amendment be proposed at a convention. As part of that research, for the first time in United States history, we gathered up the actual text from the congressional record of the applications. Now, there are other sources that were earlier than us that had citations from the congressional record. They'd have the page and so on and so forth. We actually gathered up the actual text. You can click on the links there and read the true text of it, which gives you a completely different viewpoint than if you just looked at the titles. We also discovered there were hundreds more than anybody had previously thought. We are just finished up now with the 800th application. And if you go to these other sources, they'll say anywhere from 400 to 500. So it's a huge amount of it, and we're not even sure that it's completely accurate as what we got. And this, as we will show a little bit, is part of the problem. The records are sent to Congress by the various state legislatures submitting these petitions. They've been doing it since 1789, on average at about one petition every 4 months. They are received by the National Records Administration, and after they've gone to Congress, and then that's it. They just are literally dumped into the records, no separation, no classification, nothing. And so you have millions of pages of records that over time have been built up, and mixed in with these somewhere are these records of this convention, which is by the Constitution specified that it must be called. Well, to call, Congress has to know when they have to call based on the applications. And if they don't have the applications, the record, they can't legitimately, as mandated by federal law. There are standards of record laws, and they're very complex. And basically they say, though, it has to be an accurate, reliable record, because public record is just, has to be that way. It's just mandated. So first problem that you have is that these things are like a big garbage pile, and buried inside them are these records. And so for the first time anyway, we were able to present the actual text and thus show, okay, you have X number of applications from the state of Maine or X from New York or whatever, and this is what they actually are asking for. This is what, so we can show that they have been applied when they were applied and what they said. And
right.
So we created that list in 2008, and we've been maintaining it ever since.
Yes, and doing a fantastic job. And the Congressional Research Service it also commended you on that. Now, we crossed paths back in 2011, early 2012, somewhere around in there. Right. And I was working with the Occupy Wall Street movement and Inter-Occupy. It was a network of different people from groups from across the country that were interested in the Article 5 process. And we invited you to come and speak to us. And you told us about all these records, and we took a look at all of these things, and we were very impressed. We didn't know about any of this stuff. And no matter how we looked at it, if it was supposed to be according to a single subject or within a certain time period, it just didn't seem to matter which legal test we would put to the applications we were going through. It seemed as though a convention call was required regardless of any test you would put to these records. So we wanted to fill in the gaps of the count to get to 2/3 of the states, which is now 34 states. And if we were at 20 states or 25 states, we wanted to, make up the difference and get to 34 and make this happen. So the question was, which states would we pursue? Which were our target states? We don't know. It was like playing the game Indian poker, where you have the card on your head and you're just supposed to guess what you have in your hand. It's a little bit difficult. So I was very interested in these applications and the count and trying to make this official. So I put together a letter with, after discussing a lot of this with our group, and Bill was part of some of those conversations as well. And we put together this letter and signed it and sent it over to the clerk at the instruction of Tom Wickham, the parliamentarian. We'd had some trouble getting an official number, and he said it was a perfectly reasonable request. So after quite a period of time, it worked its way through the speaker to the Judiciary Committee in the House. They ended up passing a rule which published the applications from states, and they've been trying to publish it at I would say a very slow pace for a very long time, since 2015.
Right, and the answer was because of your letter. The answer, when we asked the legal attorney, or the attorney for the House of Representatives, and he gave an official response. And we said, well, what's the official count of applications in Congress at this time? And his answer came back 0. We've never counted them.
Right.
And we have no process for counting them. And we said, well, how are you going to call when it's time? We don't know. Well, how's this going to be introduced? We don't know. Well, how are you going to obey the Constitution if you don't have any process to go and have? We have no idea. In other words, basically, we hit the trifecta. We're stupid. We don't know anything, and we have no way of knowing how to do it. So,
right.
It was a classic response, but it basically started this whole thing of Congress going to the Judiciary Committee. And ultimately, this rule was passed in the House. And that's a significant point that everyone has to understand. This only is affecting right now the House. The Senate has not acted or dealt with it.
Absolutely.
So
now,
that's where we got with the rule that they start gathering their own set of applications.
Right. Now, we were watching the list grow on the clerk's website as it crossed the 34 state mark. I began calling the clerk's office again. Robert Borden is now the new attorney for the clerk's office, and started talking about these applications with him. At that point, when I finally got him on the phone, it had been a couple of few weeks, I think, before I actually got him on the phone. They had added a couple more states. I think at that point we were up to 36 states, 2 states beyond the required number. And I finally got him on the phone. He was amazed that all this stuff was happening. And he was new. He had just moved over there from the Benghazi committee. He was legal advisor for that, lead legal advisor for that committee. And so he's basically like, it's not my fault. We're just dealing with this as it is. He was very familiar with it, intimately familiar with it. He actually knew the list that was on their site more than I did. He was referring to specifics in the list that I wasn't really aware of. I wasn't looking at it quite that closely, but he was. So he was intimately familiar with the list and could definitely answer the questions. This moved on a little bit further when Evan Ravitz, another person who had been working with us, a friend of ours, had also noticed that we had crossed the required number on this list. He gets a hold of his friend who he used to do some research for, Congressman Jared Polis from Colorado's 2nd Congressional District, and starts telling him about this list. Jared takes a look at the list and really didn't understand a lot of this, and sought some pointers from the Parliamentarian. And so we ended up having a conversation with the Parliamentarian. And Bill, could you kind of go into the basis of why we were there on that call?
Well, there's another part of the story that needs to be brought up to get it fully complete. Companion to this, an independent, Congressman Luke Messer of Indiana, 6th District, I think he's, 6th District, had also got some interest in regards to the fact that, as I mentioned earlier, these records were in NARA, the National Archives and Records Administration. Now, the thing is, and here came another problem, they are in what are known as the congressional records. And ordinarily, under the law, NARA could be requested to go in and pull out the records. Simple letter from a congressman or even an individual, NARA would go in, pull the records out. So you could simply expect, okay, you send one letter to the National Records Administration, you say, hey, we want the applications, go pull them out. Well, turns out that's not the case. Turns out the congressional records, the ones where all the applications are owned by Congress. And NARA, in about 2014, if memory serves, 2015, in that range, sent a letter back to Congressman Messer, who had requested, and basically said, sorry, Congressman, this is your problem. We can't do it, and we're not going to do anything. So here's your 800 applications. And so Congressman Messer, upshot of it all, was he wasn't particularly impressed with the idea of them basically saying, no, we're not going to do what you've asked. So he wrote a proposed legislation, which ended up being stuck in the Judiciary Committee and didn't come out for a vote, which basically was called a Transparency Act, which essentially caused NARA to gather up the applications as similar to what you'd see on the FOAVC website. And that would be, the text would be actually gathered up. Now, the reason that this is so important is that federal laws, again, the records laws, demand it to be accurate and correct. In other words, if you're going to make a convention call, you actually have to have the documented proof, which is the actual applications, not the ones that sit in the congressional record, because that is secondary. You have to have the primary record, the actual applications from the states, and they actually have to be counted in some fashion of counting 1, 2, 3, 4, 5, but you have to actually have Congress do this count. It isn't something somebody can just come up with. Well, he introduced this piece of legislation, and it went nowhere. So now you had this double whammy of, okay, first of all, we don't know how many applications we got, so we don't know when we're going to call. And as the thing with the Parliamentarian eventually showed, we don't have a process to do it. And so that was the basis of how this all came into where we started talking to the Parliamentarian. The two problems. One, how do you have an application list? How do you get the application list so that you can legally make the call? And two, okay, if you're going to do this, how is it done in the House and the Senate? Because it turns out there are, and never has been in the entire history of the United States, a procedure in the United States Congress to obey Article 5. It's never existed. Not at all. The only thing that Congress ever did was in May 5th, 1789, they established the rule of how they would be counted numerically and that they would be put in the archives. But they did not that day say, okay, well, when you reach that, what are we going to do? How does it get out? But they did state there's no vote, there's no debate, and there's no committee. So that's where the background came, and that's why we got in this conversation with the Parliamentarian and say, okay, now what?
Exactly. It sure, when we looked at the clerk's website, at the time we were in the phone call, 37 states had active applications on that list with no rescission. And sure, there were some rescissions. Let's put those in a bracket. Those were additional to those 37 I'm talking about. Those 37 still had active applications. That was not a legislative question we could even raise in that conversation. The count wasn't part of it, but it was noted in that conversation that the list that we started that really kind of got the ball rolling with all of this doesn't mean anything. It's only the House. It's not the Senate. Any count that you come up with from that list is not official. So it's not even a matter of just, simple arithmetic of just counting states. It had to be a matter where it was a bicameral record of applications for both the Senate and the House. They have to match. If one's missing, they're not going to count it. But that kind of gets into another issue, kind of just a tangent away from this meeting. There was a letter many years ago with Stephen Moyer and Bernie Sanders. You've got that up on your website, Bill. Can you explain that letter real quick?
Steve Moyer, yeah. He wrote a letter to Bernie Sanders, who then sent it over to NARA and says, okay, where are the applications? They didn't even at that time even know in Congress where the applications were in all the NARA files. Well, the guy then comes back and says for the first time, well, they're over in these congressional records. We don't know where they are, but they're over there in this warehouse. Oh, well, thank you very much, basically is what it said. And here, you would count them by states. And this is a significant point that everybody has to understand. Congress, when it has ever shown any of these records, always is counted by state and date. They have never had the rules that they have right now in the House, do not require it. The Senate did a count in 1930, and it stated that it was a numeric count of applying states and 2/3. So in other words, where the Congress has actually done this, they do not consider state and date. Or they do consider state and date. They do not consider amendment subject. And the reason is because these applications are asking that a convention propose this amendment. So if they want the convention to do it, obviously Congress can't make that decision. Otherwise, they would be proposing it. So if they're going to propose it, they'd have to do it by 2/3 of each house. They can't go in a majority vote or any kind of decision and say, okay, well, you're only going to see this and this and this, because that's proposing an amendment. You're in the process of proposing an amendment. So that is why it's a numeric count, because that way it all goes over to the convention where the delegates are elected as required by federal law, and they then debate it and argue it and decide what they're going to do. And this is why a lot of people, they don't understand this point, is that the reason that Congress can't do the selection is because then they're proposing, they are deciding that there's going to be a balanced budget or a right to life amendment or whatever. And that is not what the applications say. They say they want a convention to propose it. So,
right. And they don't even claim that kind of authority themselves.
No. Congress has had a bill that was defeated a couple of times where they've tried subject, but the most recent example was the House itself, where they tried to set that up in this last session of Congress. They tried to put a rule in, and the Congress knocked it down cold, and they were concerned about the constitutional questions, and that was the basic question. It says 2/3. It doesn't say same subject, and it was never discussed in the House of Representatives. And you've got court rulings on top of that by the Supreme Court that make it quite clear that it is a numeric count of applying states. In other words, we have to understand Article 5 is a process. It is an actual, like a recipe. Okay, you take, 2/3 of the applying states, mix in one convention, add in a dash of ratification, and you get an amendment. It literally is like a recipe. Well, you aren't going to get the right recipe out, the right thing cooked, if you add in 2/3 cups instead of 1/3 cup. Same process, same idea. It's a locked-in process, and the Supreme Court has pointed this out. That's why they have said there's no interpolation, rules of construction, or addition, and there's nothing in Article 5 that says subject. So it's a numeric count of states. And if you think about it politically, it makes perfect sense. If you had it that Congress made these decisions, then they could simply veto it, and they don't want it. And that's what it's not intended. It's intended to work around Congress. Well, it can't work around it if you're giving them, such as, for example, everybody talks about their have rescissions. They can't do that, because if it's peremptory, you can't give Congress an excuse, which is why rescissions don't exist. Because, and federal law, by the way, it also says it's a legal fiction. There's no constitution, state constitution, that gives the states the right to rescind even so much as a single federal record. So this is why rescissions, for example, don't work. Any of it. It's a strict numeric count of states.
Right. And actually, the Congressional Research Service did bring it up again in their report about the rescissions, still being ambiguous as to whether, that they're going to count or not. Another real quick point to make from the Congressional Research Service that would support that as well is that they did make a note that at present, and I'm quoting from that latest Congressional Research Service report from November of 2017, says, at present, the following organizations, Compact for America, Single Subject Amendment, and Restoring Freedom, all propose conventions to consider specifically worded amendments, notwithstanding the opinion expressed by the House Judiciary Committee in 1993 that an application requesting an up or down vote on a specifically worded amendment cannot be considered valid, which really kind of torpedoes this idea. It has to be the same subject. The wording of Article 5 would imply a singular subject, but if you're looking at it the way Bill says, it's an application purporting to be an application for an Article 5 convention, or it's not. The subject is irrelevant.
Right.
That's why they're the same. Again, there were two things. We need to have a bicameral collection of records, number one, so that both houses can recognize that or acknowledge the fact without debate or sending it to committee that we have passed that threshold of 2/3 and they're required to call a convention. Now, the other thing that we need is a joint rule, because not a single member of Congress can call a convention. I believed that before this meeting, but I came out of it knowing that no single member or committee or even House, usually when you pass a law, it starts in the House, goes to the Senate, I thought that would be the same with this process. It could originate from either house, I would think. Well, we were not right about that. The Constitution being basically the only rule that exists to govern this process within Congress, and we'll get to that a little bit later, doesn't specify one house or the other. It does say that 2/3 of the House can propose amendment and then 2/3 of the Senate. But then it also says that Congress must call. And if you're considering a legislative process with those kinds of instructions, there's no other way for them to interpret that this is a bicameral action. It's going to be a joint action. And for that, there's no rule, no process for this to happen. So really, there was no ambiguity. This is the parliamentarian explaining to a congressman how you get this convention to happen. We need two things. And if you want an Article 5 convention to happen as well, you're also going to run into these two things. All roads, all efforts in the Article 5 movement are eventually going to run into this common obstacle. There's no way for this process to happen. There's no procedure for it. We need to create a joint rule between the House and the Senate so they can both respond to the records in a bicameral fashion. Again, there is the Transparency Act that is already created on the table in the Judiciary Committee now, which would assign those records to NARA and the count, and then they would tell Congress it's a bicameral solution. We absolutely support that. Bill, you had a hand in that as well. It would immediately go back the first year, back to 1950, and get all of those records on a public website that NARA would be responsible for generating and maintaining.
First of all, what a bicameral rule is. In a bicameral rule, they existed in the United States Congress as dealing with subjects that both houses of Congress had to deal with. Primarily, they dealt with such things as the 12th Amendment when it was passed in place. There was a bicameral rule at that point. There were other things that they did, letters from the president, so on and so forth, messages. Now, these existed up to about 1876, and then at that point, they were abandoned by Congress because they got more and more difficult to get passed in both houses. And what they are is simply a rule that is exactly the same wordage in both houses of Congress that deals with a circumstance that the two houses have to address as a Congress. And the Parliamentarian made it clear, because Article 5 said the Congress must propose it, that therefore it has to be an action, as if the body of Congress, the House and Senate, were one body, is the best way to think of it. It's literally a rule for the one body of Congress to use. Now, the bicameral rule has to entail the following things. It has to set up a process, either with the Transparency Act or under its own authority, that gathers up the applications so that somebody designated, probably the clerks, can notify Congress when the events have occurred or at what time, and allows for the publication of them, the public review, so on and so forth. It then has to have a process in that rules that set up, okay, what does Congress do with this? When does it do with it? How does it do with it? What do they do to deal with it? In other words, the calling of the actual Congress, hence a committee of the whole. Who runs this committee when it's done? What is the business of it? How much priority? In other words, this whole process we're talking about is the pragmatic side that a lot of people don't understand about the United States government. It has a very, very definite process that is behind the scenes that nobody even thinks about. For example, when you pass a piece of legislation, any piece of legislation, the review process and the accuracy process that goes into it is absolutely phenomenal. It is studied and read by literally hundreds of people, not for the political part, but to make sure that when that piece is published, it is exactly what Congress and the president have signed, so that there is absolutely no error, not even so much as a period, for example. It is precisely accurate. Well, the same thing has to be here, so that the process is legally viable. In other words, you can rely that when a call is made, absolutely that there is the 34 applications from the states and that they are legitimate applications. Now, therefore, a process of certification by the states. Now, fortunately, all the states have always used the state Secretary of States to transmit that they are certified. And that is important. These are official state records now. They're not anything else. They've never done it any other way. And that's important because a state certified record has itself a certification process back in each state. And that means that, therefore, these public records, and that's what they are, can therefore be relied upon to be the basis of a convention call. And after you've gathered them up, then, okay, what are you going to have in this convention call? What is Congress going to present? How is it going to be submitted to the states? Who do they send it to? All of these procedural questions must exist, according to the Parliamentarian, before a convention call can be issued. And the reason that they do this is because the rules of the House and the Senate do not permit a member of the Congress to stand up and say to the chairman, Mr. Chairman, I have a record here of a congressional record, and it shows 34 states have applied. I move the Congress consider it. Under the rules of the House and Senate at the time, that would be ruled out of order. And it's maybe not the way it should be, I'll grant you, but it is the rules of the Senate and of the House. So that is why these rules have to exist, because there is no way to process the whole thing. And it doesn't matter if you believe in same subject, anything. It's all going to hit the same concrete wall. If you don't have a process in place, they're not going to do it. Now, like I said a while earlier, the balanced budget is probably the one that everybody's thinking of, and they said they got 28 states. Well, when they get to 34, they're going to find out two things, which Dan and I have already discovered. First of all, they're going to call up the clerk of the House and say, well, where is our 34 applications? You know, how many have you got? And they'll say 0. And then they'll say, okay, well, how about the convention of state applications? Well, they don't even exist, and it's at 0. And they're going to go freaking out. And it's like, no, that's the actual count. There is no official count of convention of state applications, nor balanced budget, nor anything else. And until you have the process in Congress, that's as far as it's going to go. And I am hoping that these people do learn this fact and come to understand, and we've been urging this for years. The problem is not getting more applications. You got all the applications in the world. You got 11 conventions right now. How many do you think you're going to need?
And they can't really depend on that political will to manifest itself just as they're about ready to turn in those 34 states. And, you know, regardless of how much support they have within those states at that moment, you know, it's required by the Constitution. And, you know, there's no reason to have that kind of a standard. Although even in the Congressional Research Service report, it concluded at the end, well, maybe it's a good thing that we don't have this convention happening because they're not clamoring for it out in the streets for a convention. Well, most people don't know that this method to change the Constitution exists, let alone clamor for it. So you know, that's kind of a strange standard, but it's not a standard. It's merely like you said, a numerical count of states applying for a convention to propose amendments in the plural. Well, that's all the applications need to do.
The same logic could also be applied to talking about the appointment of a Supreme Court justice or the president. Nobody actually, as far as I know, has ever clamored for the appointment of a Supreme Court justice. Nobody has actually ever clamored in recent time that I can think of for the election of a president. I'm talking about the individual. I'm talking about the actual, how many people have you stood up and said, we need to elect a president? They don't do it. Okay. I mean, if you stop and think about it, if that's the logic they do, that they don't have a process in place, there would be no president. And the Constitution did address that. It didn't do it in Article 5, and that was a mistake. They should have put that in the original Article 5 and said, okay, this is how you're going to process those applications. One sentence would have made a heck of a big difference in the way things have gone in the history.
Right. Well, and again, to kind of wrap up here too, we had this conversation last summer, and Congressman Polis has started his campaign for governor in Colorado. He was great help to us. I don't besmirch him for having a wide degree of interests and pursuits, and he is spread pretty thin, but there hasn't been any activity going forward with this in the Rules Committee of the House or the Judiciary Committee with the Transparency Act. And we do need to build that kind of political pressure because there is no urgency to this, and time is of the essence. And we do have a society that is kind of crumbling around us and more division. So, this is a fantastic opportunity. I hope that everybody realizes that there is a path here and can help us kind of achieve these goals. This is kind of an all hands on deck moment, and we hope that you help us and we succeed here.